order and ask Marty if he would please do an official roll call for attendance.
Sorry.
Oh.
Member Acharya is not here. Vice Chairman Langston.
Present.
Member Michael is not present. Member Roebuck.
Present.
Member Sack.
Present.
Member Toterai.
Present.
And Chairman Pritchard.
Present.
We have 2 members absent, but we have a quorum.
Thank you. So Chris Roebuck again will be the voting member of this evening. So any changes to the agenda from your side, Michelle?
No, they're not, Chairman.
Okay, then we'll go ahead with approval of the minutes. Michelle, I think you had Michelle and Marty, I think you had a minor change that you probably should bring to our attention.
Okay, I'll go ahead and do that. On page 4, paragraph 3, I added the word production facility space when referring to the life sciences uses. It was named in Kimley Horn's application packet.
Very good. Any other changes or corrections to the minutes? Hearing none, we'll call for a motion to approve the September minutes. Would somebody like to propose a motion to approve the minutes?
It looks like indicated in the chat box, Member Terry and Member Langston. If you could verbally make those motions, please.
Sure, I'll make a motion to approve the minutes.
And do I have a second?
Second.
Thank you. Second, Ken Stack. All in favor, say aye.
Nope, well, I'm sorry. I have to call them.
Old habits.
I have to call the roll, please. Vice Chairman Langston.
Aye.
Member Roebuck.
Aye.
Member Sack.
Aye.
Member Toterai.
Aye.
Chairman Pritchard.
Aye.
The motion to approve the minutes was passed unanimously.
Thank you, Marty. So, Planning Manager Lawson, do you wish for us to mute while you're speaking, or how would you like to proceed?
Yeah, I think that would be fine. The only thing is I can't see you because I'm sharing my screen. So if you have a question or comment, please just feel free to ask and unmute yourself and ask me to stop or slow down or any kind of clarification you need. So I think that'd be fine if you muted yourself while I was speaking.
Okay. Thank you. All right.
All right. You guys ready for me to go ahead?
Yes, I think we are.
Okay, thank you. Okay, so good evening. Tonight we're just going to do a training on 2 new responsibilities that were assigned to the Planning and Zoning Board. Like I just said, I'm going to run through my slides, kind of give an overview of the 2 new applications you guys could hear. And then after that, I've got 2 brief exercises where I'm just going to run through, a potential example of what you might hear, just to give you almost a real life example. So like I said, I can't see you. So if you've got a question, comment, if I'm going too fast or you can't hear me, please just say something. I'd be happy to slow down or repeat myself. So earlier this year, Town Council approved several text amendments which shifted responsibilities around to various boards and also dissolved the Board of Adjustment. So the Board of Adjustment had heard applications for variances and administrative appeals, and now the Planning and Zoning Board will hear those decisions or hear those applications. These will be final decisions made, so you will not be making a recommendation to Town Council or any other board. This group, the Planning and Zoning Board, would make the final decisions. So previously, the PZB had heard special use permits And these are the same type of applications, meaning that they are quasi-judicial or evidentiary hearings. So quasi-judicial hearings, what are they? How do they differ from hearing a site plan or something else like that? So they're known as evidentiary hearings because they're supposed to proceed similar to a courtroom. So as for rezoning, you almost have a broad discretion of why you should approve it or deny it. But for this, for a quasi-judicial or evidentiary hearing, you're supposed to compile the record and make your decision based on evidence and based on witnesses that have standing. So again, the review procedure will be similar to how a courtroom proceeds. So my 4 things I put on here, just you would adjudicate how the UDO applies to particular situations based on the record. Applicants have to testify and provide why they deserve a positive vote according to the standards that are set in the UDO. Your decision will be based on competent material and substantial evidence, which is found in the record. And the last one is no ex parte communications allowed. So any contact or any conversations, or if you share any thoughts about this case, it must be held within the hearing. You're not allowed to talk to an applicant, a neighbor, anybody outside of the hearing itself. And I'll get into that a little more later on. So the first of these 2 responsibilities that were given to the Planning and Zoning Board is to hear applications for a variance. So what's a variance? A variance allows for a deviation of the UDO standards for one specific request. So a common request could include a reduction in a setback or to allow a property to go over the maximum lot coverage. So just to read through my slide, it'll only be approved if you reach all the conclusions listed in the UDO, and I believe there's 8 or 9 of them, and we'll get into those later. So it requires a 4/5 majority or 4 board members for approval. So it's not just a simple majority, got to have 4 out of 5. Absent board members still count towards that majority. So you as a board could approve the application, as it's submitted. You could approve it subject to conditions that apply directly to the application, or you could simply deny the application. So because these are specific and unique to a specific parcel or project, no precedence is set. So if you grant a variance for someone who wanted a side setback reduction to build a special deck or something, that doesn't mean that everyone else in town can apply to get that same setback. It has to be very specific and very unique to that project or that parcel. The other kind of application, which you may hear now, is an administrative appeal. So this is just what the slide says. You would review the decision of a town administrative officer, and if there's substantial evidence in the record of an error, then the board can modify or reverse the officer's decision. Most likely the officer you're going to be reviewing, the officer that makes the decision that you're going to review, is probably going to be Michelle acting as planning director. So for example, there's a developer there's a gray area in our UDO that the developer really feels gives them leeway to do something. They apply for a formal decision made by the planning director. She goes against what they think the code actually says. So there's a gray area in the code. At that point, they could apply for an administrative appeal, and you, acting as the PZB, would either uphold Michelle's decision as the planning director, or you could overturn it, or again, you could approve it subject to certain conditions. And depending on the outcome of this one, a precedence could be set. So for example, if someone is arguing that their road or their driveway is actually a road and it affects other things, if you overturn Michelle's decision and say, no, Michelle, you said this was a driveway, but we actually considered a road, that could affect future cases, because then she would need to look at similar situations the way you had ruled. So again, just a simple majority for this one, and I'll get into some more about it later on. So for any quasi-judicial hearing or evidentiary hearing, there are 3 types of public participation. So this is not, in some other cases such as rezoning, you could live in town, you could live anywhere else, and you could come speak and speak your mind about the case. In these kind of hearings, there's only three parties. So the first one is applicant testimony. I think that's fairly straightforward. That's the person who applied for it. They get to come speak to you and argue their case. The second one is parties with legal standing. This could be a variety of people, but it's generally people associated with the case. So it could be neighbors, anybody that's going to be impacted by the decision you would make to grant a variance or administrative adjustment. The third person is a non-party witness testimony. So oftentimes these type of people are real estate appraisers, traffic engineers, experts in sound, things like that. These are people that are come and they can be a witness to talk about, how the decision made on a variance or administrative appeal would impact the neighbors, the traffic, quality of life, things like that. So anyone that speaks must be sworn in. There will be a public comment session, but this will be outside of the hearing itself. And then again, my last slide is just no participation outside the public hearing. And I'm gonna say that a few times through my PowerPoint here, just to remind you that you're not allowed to have any kind of contact outside the hearing. And it can be uncomfortable if someone, you see someone at the grocery store and they want to talk about it, but I just want to really, really drill that in. Not to speak about a case outside the public hearing. So let's get to voting. So like I said, a variance requires 4/5 majority of the board of 4 members, and they must reach each conclusion listed on this slide. It's also 2.5.16 of the UDO. So the procedure would go like this. The chairman would open up the voting time, and you would vote on each standard. And to receive a variance, the applicant has to get a 4/5 majority vote for each standard. And if they don't, then a variance is not granted. So for an administrative appeal, like I said, this one only requires a simple majority, so it would be 3 members. And you would have to adhere to the standards found in 2.5.22 of the UDO. And these are listed below. So these are, the other one had, I think, 8 or 9. This is just 2, but this is really based off the record and the specific kind of case that you would hear. So this is more for your interpretation, but you need to go by these 2 standards here. So conflicts of interest. So you're going to have to abstain from participating or voting on application if you feel that it would affect a person's constitutional rights and impartial decision maker. So again, this is a proceeding like a courtroom. A judge is supposed to be an impartial decision maker and not have any kind of potential gain or loss based on how they make a decision. So violations of due process include, but are not limited to, and these are straight from the general statutes, having a fixed opinion prior to a hearing. Human nature, you're going to have an opinion on it probably before you go into the hearing, but it needs to be able to change based on what the record shows. Second one, again, you cannot have any communications outside of the hearing with someone. The third one is a close family, business, or other associational relationship with an affected person. So if you have any of those, you're going to need to abstain. And the final one is a financial interest in the outcome of the matter. So any of those, you should abstain from the hearing itself. So what is a familiar relationship? These are also straight from the general statutes. It's a spouse, parent, child, brother, sister, grandparent, or grandchild, and these include steps, halves, and in-law relationships. So what happens if a PZB member tries to participate, but someone else kind of questions whether they have a conflict of interest? Well, right here. So, if an objection is raised to one of you participating and you don't automatically just recuse yourself at that point, the remaining members of the board must vote on the objection. So if there's a majority vote that the other person does have a conflict of interest, they will have to then recuse themselves. And this objection can come from fellow PZB members, staff, or any parties with legal standing. Okay, so open meetings law. North Carolina's got an open meetings law. We have to do business in the public. but the participation should be limited to those with legal standing, as previously mentioned. You are allowed to go in closed session if you're consulting with the town attorney on legal matters. So as far as my third bullet point here, if you receive any correspondence relating to a matter which is a quasi-judicial item, such as a variance, you should really just direct that to the planning director and not other board members. If you have any questions about the hearings that's coming up before the meeting, you should direct that to the planning director. And again, I hit avoid talking about the case outside of the meeting. My career has lasted about 7 years now. The only time I've seen a case like this be overturned in court is because several of the board members had met with a developer outside of the quasi-judicial hearing. And when it was appealed, the next court up tossed it out immediately. So just avoid any outside conversations. Just if you have any questions, just direct them to the planning director, maybe even the town attorney. So as far as procedure, you may continue a quasi-judicial hearing by setting a specific date and time for the continuance. Ideally, you would want to have a meeting, and within that hearing, you're going to have everyone there to provide testimony. You're going to have the record be built through evidence. You'd really like to get through a meeting, ideally in one meeting. However, things happen. It could last longer. It could be a controversial case. You can continue it to a specific date and time. And like I said, for these two applications, you will have the final decision-making authority. So this is not going to go to town council. This is not going to go to the town manager or anybody else for a decision. You are the final decision maker. If you make a decision and a party, wants to appeal it, they have to appeal within 30 days, and then that civil action goes to the judicial system. So just some key takeaways from some stuff I said tonight. These are evidentiary hearings and must be decided by the record. So you're going to act as a jury, and you must recuse yourself if you have a conflict of interest or an unchangeable predetermined viewpoint of the application. You will make the final decision to allow for a variance to the UDO or to overturn the administrative official's decision. And, again, just no communication about the application is allowed outside the public hearing. If you are in doubt, please contact the planning director or the town attorney, or me if you need to, if you can't get up one of them. The quote at the bottom is something that one of the professors of the School of Government provided, saying, if you happen to be at a grocery store and you're stuck in line behind someone who keeps asking you questions, it gets uncomfortable, you can just tell them, I understand what you're asking, but I legally cannot discuss the application outside the public hearing. And again, you can always direct that person, or anybody else to the planning director or the town attorney. So that's my brief overview of these two applications. At this time, do you have any questions? And then after this, I'm going to go over the two brief exercises that I also have.
Thank you, Chris. I thought that was a great summary.
Thank you.
I have one comment type question and another question.
Okay.
Let's start with the easy one first. If somebody does object to a member's participation, where and how does that member have an opportunity to rebut that?
That is an excellent question.
And we probably play it by ear, I think, because it came up.
Yeah, let me go back to that.
Yeah.
So this is the slide I think you're referring to. So again, if somebody objects to one of you participating in the meeting and says that you might have a conflict of interest, this is where they would object, and the rest of you could vote, and a majority vote would determine whether that person could participate or not. As far as how this could work out, I believe we're also going to edit your procedural handbook, and maybe this could be hashed out a little more detail at that point. For now, I would just recommend that the person who objects gets to say, I do object, and this is the reason why. The board member themselves says, well, actually, no, these are the things I'm going to defend myself with. I actually don't have a conflict of interest for these reasons. If it gets to the point where there's a true dispute that cannot be settled, I think we really would have to consult the town attorney at that point and have him decide, how should we proceed? How are we going to protect ourselves? Because ultimately we don't want a case to be heard, a decision to be made, and then it goes up to the next level of the court system and they overturn your decision. So I don't have a super detailed answer, but I do think as we work on adjusting your handbook to update to the new items that the PCB will hear, that is a good thing we need to think about and probably hash out in more detail as far as the procedural rules.
And just to add to that, just like with a legislative decision, if one of you thinks that you may have a conflict of interest, please reach out ahead of the meeting. A lot of times those conversations happen with myself and the town attorney prior to the meeting, and we can decide if it's appropriate to have one of the alternates step in. So most of those discussions do typically happen before the meeting occurs.
Yeah.
But if it is a question that is raised at the meeting, that's when the PZB would vote.
Very good. Thank you both. So my comment/question is on public participation.
Okay.
In special use permits that we've had, which have been quasi-judicial, it's been somewhat frustrating that the parties affected have been told that they are not licensed appraisers or don't have some sort of official credentials. I'm thinking, as an example, there was a situation where there was to be a cell tower right by a residential subdivision, and the neighbors knew intimate details about their own property and the subdivision and the site for where the cell phone tower was going to be, but were not sort of recognized by the quasi-judicial attorney who was kind of helping to chair that. But in your description, you said that it would be people who are associated with the decision or neighbors, etc. Mm-hmm. Any comments on that? Or again, it's probably something that we deal with when it actually arises, but it might be an idea to just think about that.
Yeah. Well, I think that's an excellent question. This is kind of a gray line, and really, I'm not an attorney, but I've had a little bit of experience, and I'll try to answer it in this form. This is a quasi-judicial proceeding, so like a courtroom. So you can have a neighbor that can come and say a cell phone tower is going up, and that neighbor could have, and I'm not speaking, I don't know the case that you cited, but I'll just say this. The neighbor could come and they could say things that they are experts on in that particular property. But if that person comes and they just say, the standard things we hear often, which are, it's going to hurt my property value, it's going to cause my quality of life to go down, it's going to do this, this, and this, they have to have something to back that up. They can't really just come in and just say, make blanket statements, accusing cell phone or something else that's going to happen that's just going to ruin their property life. They can say it, but they got to have something that can back that up. And that's really where your real estate appraiser or a traffic expert can come in. So definitely it's going to be something that will be case by case basis. And again, we'll talk with the town attorney on this, but they have standing, they can speak, but if they're not an expert in, like I said, traffic or real estate appraisal, I would just be really hesitant about them coming in and kind of making blanket statements like that. Does that make sense? I know it's not a great answer, but we'll have to hash out the details when something like that happens.
I think that was a good answer.
Okay, thank you.
And case by case, I think is probably what would.
Yes, cross that bridge when we reach it.
Right. That's why we're a board of human beings, not a series of computer robots. So anybody else have any questions for Chris here? Go ahead, Lee.
And more of a comment. So I was on the Board of Adjustment before, and my recollection was that neighbors are allowed to hire an appraiser or engineer or whoever else, and they can present that evidence in these types of cases, and they are able to, and that can be accepted sort of into the record or whatever you want to call it. They just aren't allowed to come in there and just say, oh, I think X, Y, and Z about my property value because they're not an expert. But they are allowed to hire people, and then that would be on their behalf. That does give them an option. Obviously, it's an option that costs money, but that is available in this type of hearing.
Mm-hmm. Yeah, that's a good point. And yes, yeah, I agree with that.
Thank you, Dean. Anybody else have any comments or questions?
If you don't, I can move on to my exercises. If you'd like, Mr. Chairman, we can also come back if anybody has questions after those.
I think that's good. Important question. Are we going to get graded on this exercise?
No, not today.
Phew,
not today.
That's a relief. Thank you. Please go ahead.
All right. So the first one deals with a variance. And if I can get this little bottom bar out of the way. So if you can see this is a plot plan for a new home. So the home's here in the middle. If you can follow my mouse, here's the driveway, and the road is at the bottom of your screen. Okay, so I'm just setting this up, and here's all the yard out here. So that red line shows the 30-foot front yard setback. So nothing can be built in between that 30-foot front yard setback and Amanda Court down here. So everything has to be built behind it. So you can see the house, there's a porch, some kind of deck out back. So everything's behind the setback like it's supposed to be. Well, this property owner really wants this covered porch out front, which I show as a green blob here. And it's their dream covered porch, and they're not going to stop. They want it, and they don't care what I say as staff. They want to know, what's the next application? How do I get this before a board who can really help me out?
It's always there.
So they're going to apply for a variance to reduce this front yard setback and scoot it closer to the road so that they can build this covered porch here. So they apply for a variance, and this would reduce the front yard setback from 30 feet, where the red line is, down to 15 feet, which is somewhere, closer to the road, which would allow them to build their front covered porch here. So it comes to you as a PZB, and you have to review it based on these standards on the left of your screen, which is A through H. Like I said, is in the procedure, you'll hear the case, you'll review the evidence, and then the chairperson would open up voting, and you would just go down from A, B, C, all the way to H, and you would vote on each standard. So again, you'd start at A, and if you'd go through all of them, no matter how the vote comes out. But if they're all approved, then the variance would be granted. But if one of them is denied, the variance is not granted. And so it seems overwhelming, but it's meant so that the rules are followed by everyone and fair. So I guess I would turn it back over to you, Mr. Chairman. You can handle this however you want. You can run through it if you'd like, but basically the board would go through each of these and would vote on them. And at the end of it, we would know whether the variance is granted or not. So I guess let me know if that's kind of making sense, if you're seeing where I was going with this exercise.
I do have a question on the process on this. So
okay.
As you work through this, do you just go and do a vote on each of them in turn, or do you do them collectively? So a question would be is, if it doesn't pass A by a 4 to 5, do you just stop and done?
Yeah, so you would vote on each one individually. So there would be 1, 2, 3, 4, 5, 6. There'd be 7 votes, and each time they would have to get that supermajority to approve. However, say we went to A and everyone voted no for the variance, you would still need to go through each one of the standards, because at that point the applicant could then appeal the decision to the court system, and we'd want to know what was approved, what wasn't approved, kind of the whole record of what happened.
That makes sense.
I would say historically we've had discussion about them one at a time, but then we've taken one vote on all of them based on the record and discussion. But if it is a denial, you need to indicate in that motion what standard was not met and why based on that prior discussion.
Yeah, that's good. And I'll just say in this case, you know, I guess I know this property a little better. It's a house in a standard neighborhood. It's a relatively flat property, and I don't see a need for a variance in this case. I mean, they could probably shift the porch somewhere else, you know. But again, if you approve or deny it, you're not setting a precedent. You are basing your decision off this one particular property and all the evidence that comes out of the hearing. So that's the last slide I have on variance. Does anybody else have any other questions or comments at this time?
Would you like us to go through this just so that we've completed the exercise?
If you would like to, sure. I'll leave that up to you as chairperson.
I think that might be valuable. It's always better to do this, you know, where it doesn't matter.
Yeah.
Whereas a real case. So I think what I would like to do then is let's go item A. Are there any extraordinary or exceptional conditions that don't generally apply to other lands or structures in the vicinity? I mean, I don't see any topographical issues. We don't know what the neighbors look like. That might be good. If it were a real case, it would be good to know, you know, where the other houses are and so on. Would anybody like to play devil's advocate and suggest that there might be some extraordinary or exceptional conditions?
I have a question. Yeah, is this an existing home or is it a proposed home?
That's a good question. This will be a proposed home being built by just a standard builder, but there's a couple moving into this home and they bought it. It's still under construction and they really want to add this covered porch on the front of it.
So that, I guess in that case, it'd be kind of hard to, I mean, I don't see any reason why the house can't just be pushed back on the lot. It wouldn't approach the other setbacks by doing that. Just make the backyard slightly small, right?
That could be an option. All right, well, let's change it then. That's a good point. This house has been there since 1950. They can't move it, and they want this covered porch.
Okay. So, I mean, yeah, I guess the same thing with Peter. I mean, if there seems to be plenty of side yard. I mean, the porch could just wrap the side of the house, and you would still have a large porch there. I mean, I guess it is kind of hard to see where there is any extraordinary circumstance in this particular case. I mean,
yeah.
I think I might be more inclined to look for a variance if there was some reason, like the topography was, you know, as it says in Chris's point, if there's a topographical issue, or maybe there's some fantastically well-preserved oak tree somewhere that, you know, means they can't move it around. But I have a hard time imagining an extraordinary or exceptional condition. So if you think that we would reach a conclusion that's in favor of the applicant on item A, please demute and indicate. Otherwise, I'll assume that we think that they haven't won on item A. Well, item B kind of follows from that, and I can understand that if the applicant or the owner of the land had altered the topography so that it was now difficult to put the porch on the side or some other way, then we might be more sympathetic on item B. Item C kind of follows from that also. feel free to chime in if you think that you could make a hypothetical case for the landowner here.
This is Chris. I don't think we make hypothetical cases for the landowners. I think, in fact, we're not even allowed to ask questions about any materials they didn't bring with them. Is that correct, Chris? I mean, we're not trying to help them. They're trying to prove that there's such extenuating circumstances that the city did not meet their need. They're coming to us with that request, and it should be a complete package of some exceptional need. Am I viewing it differently?
No, for this example, I think we're looking at it both ways, but in a real life case, if someone comes to you, the burden of proof is on the applicant. And you can handle it how you'd like, in a hearing, but generally you as the board are going to let the applicant present evidence, and then you could ask questions just for clarification or otherwise. But the burden of proof will be on them. And you could, once we get into the hearing, you can see some evidence. You're probably going to start to have an opinion one way or the other. The only thing I would caution is being overwhelmingly for an applicant or overwhelmingly against an applicant, because then it may come off that you had a preconceived idea that wasn't changeable. But good question. Yeah, the burden of proof will be on the applicant.
Yeah, I understand your point, Chris. But what I was trying to do is, this is a mock example, so I was trying to look for somebody who would take the side of the homeowner so that we could kind of debate it. So in real life, I wouldn't be doing that. But
I mean, I think in real life, the cases are going to be more nuanced. I mean, the real life case that I did when I was on the Board of Adjustment was the little sort of mini shopping center across Chapel Hill Road from Northwest Village. They wanted to build that little stuff there where the mattress firm is. Because of the distances and everything else, they had to. The DOT was not going to let them have full movement across back and forth to Park West. You notice you can only turn in there at the light, and then you got to go out around the corner. And there was like a distance from one driveway to another, which is what they were asking to reduce. And of course, there was a lot of debate in there about the DOT and why they're the way they are sometimes, but certainly it was not as easy of a decision as like this, because there were some, it wasn't because of their doing, it was the DOT. There was some weirdness because of the curve that caused the distance to be, so it was a lot more back and forth and a lot more, it wasn't like this, which it sort of seems cut and dry that it's not going to happen, but.
So Peter, I do have a question, a bit of a hypothetical to make it a little bit more complicated. So let's say that this was a case where there was something in item A that would lead us to believe, hey, this might be worthy of a variance, right? So there's something in the backyard that says, hey, we can't push the house back. It's been there for 100 years, and there's an exception that is granted. So let's say you go through the process and this is okay. I know that this doesn't set precedence on things, but what happens then if the next door neighbor says, boy, that's a great idea. I think that whole front porch thing is awesome, and I want to do the same thing. And, I'm sure they would bring that to the case. Do they make the same case? It doesn't set precedence, but does it then influence future or prior cases?
Yeah, it wouldn't officially set precedence, but it would be awful hard, I feel, as the board to sit there 1 month and sell someone yes, and then the next month they have the same exact thing happen and you say no. So no official precedence, but if one neighbor has a scenario where they meet all these standards and you approve it, and the next door neighbor has the same exact scenario and the same exact situation, then I don't see a reason not to approve it. The only thought I would have, to play some kind of devil's advocate, is that it is very rare that two pieces of property are identical. Not impossible, but so trying to find a good answer. So yes, it doesn't set precedence, but if it's back to back, if it's very soon, if one neighbor can point and say, hey, look, I have all these same things, why aren't you granting me the variance when this person got it? I don't see why both couldn't get a variance. And I wouldn't know how that would I'm not a legal expert, but if someone had, similar circumstances to someone else that got a variance and the PZB denied that person, I wouldn't know if they could go to civil court and then use the previous case as an example and say, look, the board ruled on these standards and I have all those same ones. Why didn't I get a variance? So again, a case by case, but good question. And I think I answered it.
Yeah, absolutely.
Okay. Thank you.
So in fact, we would actually be at risk of setting up item D, which is the variance would not confer any special privilege. So there'd be a risk that we would confer a special privilege. So I think if I were doing this exercise again, I would say this is going to be role playing, and we would maybe ask Tim to play the role of the aggrieved homeowner. But anyway, let me grind through this. So any discussion on items C or D? So can we think of an example where on item E, it would be the minimum necessary to allow reasonable use of the land? If you had poor access, for example, if you only had an 8-foot driveway and you needed to make that larger, maybe that would be the sort of thing that would come up. Anything in your background on that, Lee or Chris? I know, Chris, you were on the board also.
Very, very few made it to the board. City does a pretty good job of working with people when they come in with these special requests.
Yeah, I mean, that's the thing. That's why they did away with the board. It was pretty rare. I mean, we only had a couple of actual cases, so they are going to be here. Like Chris said, the UDO is pretty good as far as getting things squared away. So the cases that are going to come are going to have some weird stuff about them. It's not going to be something that could have been solved.
Okay. Yeah, and just to add to that, before a variance application would happen, they would have worked with staff for a number of weeks. And we try to work with folks and try to find a way to get the project to work. And then of course there's always administrative adjustments that Michelle as planning director could grant, and that's listed in the UDO, a certain percentage. So they want a reduction setback. If they can prove why they need it, she can reduce it up to say 10%. So a lot of these things kind of get worked out. So this is definitely more of a cut and dry kind, but you're going to have, if you do get one, it's going to be much more nuanced, and there's going to be, in my professional experience, not only is there going to be, physical designs they want to build, but the applicants are going to have, some kind of emotional ties. I've seen cases where people cite, children's health as to why they need a certain room at a certain location, financial strain, or was previously mentioned, the DOT came and took half my land and now I can't, and I didn't choose to sell it. The DOT took it. So, now they want to do something that the UDO wouldn't allow, but they probably could have done if, something else hadn't happened to them.
Okay. So let me just throw it open. Anybody else have any comments or questions? I don't see or hear any. So
Would you like
There's
me to
nothing
move?
in the chat box, Chairman.
okay, thank you. So then I think we can move on. Thank you.
Okay.
Thank you, Manager Chris.
Thanks.
Two
All right.
pieces of the meeting.
So we covered variances. The next one is administrative appeal. So again, this is, there's a gray area in the code. Michelle, as planning director, issues a formal interpretation of the code letter, and that person is still not happy, and then they appeal it to the planning and zoning board. So this one might get a little complicated, but it's kind of based off a real life situation that happened several years ago that was worked out. So an applicant wants to open a manufacturing facility in the CC zoning district. It's not clear whether the use they have falls under the UDO's definition of light or medium manufacturing. So light manufacturing is allowed in the CC zoning district, but medium is not. So, you know, staff works with the person. We get them to clarify what they want to do, and we determine that their use is actually closer to our definition of medium manufacturing, and thus it's not allowed in that zoning district. At that point, the applicant files for a formal interpretation of the UDO by the planning director, arguing that their use actually is light manufacturing and should be allowed. Well, the director upholds the interpretation of staff that the use really is closer to the medium manufacturing definition. So clearly the applicant's not happy. They don't get to, you know, move their business into that location. So they file for an appeal of the interpretation of the Unified Development Ordinance. So that means it is your job as a PZB to hold a quasi-judicial hearing and either uphold, modify, or reverse the decision of the planning director based on the record. So again, this record can consist of the applicant's description of their business, you know, experts in that industry, experts on traffic, real estate appraisal, or other industry consultants. It could also be the UDO or other town documents. So you'll need to know what the definitions of light and medium manufacturing are to determine this. Oops, that's the last slide. So this doesn't really have an exercise for you, but this is just kind of an example. And I hope you kind of understand. Basically, an applicant wants to do a certain use. The planning director says, you do not comply with our UDO definition of that use. They say, well, actually, we think we do comply with that definition. And they appeal, and it comes to the planning and zoning board. And at that point, you have the very fun job of reading our UDO definitions and sorting through what they mean and what does that person's use allow them to do, whether it be light or medium or any other kind of use. So that's kind of the example I could think of for this one. Do you have any questions or comments about this? I know this is a little more difficult and not based in something you can see and kind of determine.
Again, I think this is going to be a rare situation. I like your example because there's a certain amount of subjectivity about what light and medium might be.
Right. Yeah, and that's really the point of the appeal is if it gets to the planning and zoning board, it is something that is definitely subjective. And, you know, the planning director might have had some really question themselves whether they made the right ruling or not. That at the end of the day, they had to make one. And, you know, you as the planning and zoning board will have, you know, say Michelle issues a letter, you'll have to, you know, make a ruling on her decision that she may or may not agree with. And the applicant's going to come before you, and it's not going to be cut and dry. It's going to be definitely some subjectivity, some, you know, where's the line? Where do we draw that line on what something counts as or not? And it could be other items also. It doesn't have to be an issue, you know, a letter or determining if a use is allowed in a certain zoning district or not. It could be any number of things. But yeah, that's the main point. This is going to be subjective. It's going to be definitely difficult, and this one might actually take more than one meeting if it, you know, how the record plays out, depending on that.
One question. So, and this is something that I think we had one situation on the Board of Adjustment. We kind of wish we realized at the time. We have the ability to subpoena people, do we not, in these cases?
Oof.
We did at the Board of Adjustment, but do we now? I guess.
That question I do not have an answer to. Michelle, do you have an opinion of that?
I think we would have to double check the statute and double check with Frank to confirm. And typically, if you request that you'd like to hear from someone, as just kind of a natural course of things, the hearing gets continued with a request for additional testimony, and an applicant or the town would normally provide that information to you. But if someone objects to being a part of the hearing that you feel is an important player that you need to hear from directly, I know that I haven't dealt with that personally, where that person has been unwilling to come. We would need to double check on that.
The specific instance was this shopping center. Somebody had brought up after the fact that we could have tried to get somebody from DOT to come in and try to explain themselves. Obviously they weren't coming voluntarily, but anyway, it's a kind of an edge case, but still.
So again, it's quasi-judicial, so only people with some sort of professional, shall we say, qualification to speak would be allowed to speak. So the applicant would have to have an engineer or surveyor or an appraiser. Would members of the planning staff be able to testify automatically because they are professionals?
So I always want to, just give a disclaimer that we contact the town attorney if we had really specific legal questions. But in my opinion, for something like this, for the example I gave, the applicant is going to know exactly what their business does. So they're going to know, what kind of equipment, what kind of sounds, what kind of smells it makes. So I think they could testify in this case. And I think as staff, we would maybe not be an expert on the use, but depending on what the applicant says, we could tell you, what the UDO says, how the UDO has been administered in the past, items like that.
Okay.
I would say if it were an appeal of, say, planning director position, it could be an appeal of a town engineer decision. That person, myself, would need to be there. You are required to be there as a witness to answer questions about your determination. So you're going to have myself or another official that had made a determination there, along with another staff member. Obviously, we'll be delegating that to someone else to process and see through and present to you.
Thank you. Any other questions, concerns, comments? Lee, did you have a question? No.
No questions or comments.
Okay. Well, I think we can move along then.
Okay, that's all I had tonight too. Thank you.
All right. Thank you, Chris, very much. It's interesting. Awesome responsibilities that we hope we'll never have to actually exercise. So moving along on the agenda, the next item is public comment. And that's an interesting one, given it's a virtual meeting. Marty, were there any comments that came in?
No public comments were submitted.
Okay. Then we can move along to item 6, which is staff comments. Michelle.
Thank you, Chairman. Just to go over the September newsletter with all of you, we did have a few new development applications submitted last month. One for a new Radisson Hotel on Slater Road, also one for a new convenience store at 801 Airport Boulevard, as well as 2 new rezoning applications. One of those, again, up in the Slater Road area. And then one, which is really an amendment to the plan development for Park West Village at 951 Morrisville Parkway. There were no administrative approvals in September. Town Council did approve the rezoning of 101 Holly Creek Drive, so that property at the corner of Holly Creek and Davis Drive is now zoned NAC, your neighborhood activity center. And then in other news, it has been a big month for the land use plan. We've had a number of town council meetings. 2 of them in September, I believe it was September 21st and September 22nd. Town council held work sessions. Also held virtual Q&A sessions for the public on September 14th and 15th. There is another town council work session on the land use plan occurring this Saturday. It's from 9 to 1. It's going to be town council will be in person. It is going to be a meeting that will be aired for people to listen to live. Also, I'm glad to announce a couple of promotions in the planning department. So Chris Lawson, who you heard from earlier this evening, was recently promoted from Planner 2 to Planning Manager. So I'm happy and excited to see him in that new role. Emily Langston was also promoted then to the vacant Planner 2 position. So I just want to congratulate both of them on that. And that is all I have, Chairman.
Thank you, Michelle. A couple of questions on the new development applications. Can you tell me where is the convenience store at 801 Airport Boulevard?
I'm trying to remember offhand. I believe it's a corner property. Chris, do you recall?
Yeah, it's right on the corner of Airport and Perimeter Park.
Okay.
So that would be, I think, the northwest corner.
Right.
So there's a graveyard. It's just south of that, around the corner.
Thank you. I think that was it. Any comments or questions on Michelle's newsletter?
I have. There's a couple of these that are not showing on the development map. I had kind of looked at it beforehand, like the 951 Morrisville Parkway, a couple others. I just didn't know how, like, is that Lisa, how long does it take to get loaded in?
Yeah, and my apologies for that. Right before this meeting, I was double checking on some of those and did notice that there are a couple that need updated. The person that updates that map had been on leave, so we're circling back, getting those new applications on the map for you. So give us a few days, but those should be up along with the site plans for each.
Thank you.
Okay. Hearing no other comments or questions, I guess we'll go straight to item 7, board comments. Let's start at the top of my list, which I see. Ken, do you have any comments or questions or board comments? Member Sack, do you have any comments?
Sorry about that. I was on mute. I do not.
Okay. Go ahead.
I don't have any comments.
Okay, thank you. Lee, any comments?
Just congratulations to everyone who got promoted.
Thank you.
Tim, any comments?
No comments.
And Chris?
No comments.
All right. So I'll second Lee's congratulations to you, Planning Manager Chris.
Thank you very much.
And to Emily. It's always great that I've seen many staff changes We always seem to have a great planning staff and a lot of growth from within, which is really nice to see. People gain more experience and become promoted. It's great to see that. So I think we're ready for item 8.
I will make a motion that we adjourn.
Do I have a second for that motion?
I'll second that.
Seconded by Member Sack. And Marty, would you like to roll call vote, please?
Yes, sir. Vice Chairman Langston,
Aye.
Member Roebuck,
Aye.
Member Sack,
Aye.
Member Toteri,
Aye.
Chairman Pritchard.
Aye.
The motion was approved unanimously to adjourn.
Thank you. We are adjourned. Thank you, everybody.
Thank you.